Hello everyone and welcome to our webinar today. I'm very excited to see that so many of you have decided to join us. This webinar forms part of the Access to Justice for a Greener Europe project. This is a 3-year project that we, Client Earth, do together with an NGO network called Justice and Environment, and it's financed by the European Commission LIFE project. This is the 9th webinar we've organized under this project, and you can find the previous webinars and also other material on our website. We've included a link to that in the end. Each webinar explains one aspect of the access to justice rights that European citizens and NGOs have hold, and these are most prominently included in the Aarhus Convention. For those of you less familiar with the topic, the Aarhus Convention is a binding international treaty that has been ratified by the EU and by all of its member states, and it includes a provision, that's Article 9, that gives rights to access to obtain administrative and court review in environmental matters. So this is what this is all about. And today we focus on one very specific aspect of the European Union's implementation of that provision. And these are the access to justice rights under the Industrial Emissions Directive. This is first and foremost an implementation of the right to access to justice in permitting procedures. So that's Article 9.2 of the Convention. And this is the 3rd webinar that we had on this specific aspect. So now, without further ado, I will present to you today's speakers, which are all great experts on this topic and have a lot of very practical experience. So I'm very excited about this. We will first hear from Sam Bright. Sam is a lawyer at Client Earth and the lead of our core team. He will give a more general introduction into the Industrial Emissions Directive and its provisions. And then we will hear from Dominic Doyle and Regina Stoilova. Dominique is a lawyer at Client Earth's core team as well. And Regina is an attorney at law working for Sasim, which is Friends of the Earth Bulgaria, one of our close partner organizations. And Regina and Dominique will present an ongoing litigation in Bulgaria concerning coal-fired power plant there. So this will be a practical example to show you how this works, or how we use the Industrial Emissions Directive in practice and try to enforce them in the national court. So now I'm calling on Sam to start off today, and we will have a Q&A session afterwards. As you see, there's a question tab or that you have on your right side, so you can already type away, and then after I will guide through the Q&A at the end of the presentations. Sam, the floor is yours.
Thanks, Sebastian. Hello, everyone. Thank you for coming today. I should start by saying I work a lot on the Industrial Emissions Directive. I don't normally think about it through the lens of access to justice considerations. This is the first time I've done any kind of webinar on the topic from that perspective. So hopefully we do it in a way which is helpful and interesting from that perspective. Normally we're focused a bit more on the substantive aspects of the litigation that we're working on in the national courts, which obviously does also concern the access to justice elements. So here is the overview of what we'll be looking at. I'll be dealing with part 1 and Regina and Dominique part 2. So I'm going to focus on firstly going over the background, the IED, what it does, why it's there. Secondly, some of the core substantive obligations in the IED. I think it's important to understand that so you get a context for the scope of the discussion around access to justice. And then thinking a bit about IED cases, IED-related cases at the national level. In the section where I go into the substantive aspects of the IED, the slides will start getting extremely complicated and detailed. Don't worry, I'm not going to spend too long on each slide, and the idea is partly just to demonstrate the complexity and some of the issues that raises for access to justice. So, what is the IED? The Industrial Emissions Directive from 2010 regulates over 50,000 industrial installations across the EU, or it did before the UK exited the EU. I'm not sure what the number is now. And this includes installations large and some of them a bit smaller, everything from coal plants to pig farms, laundrettes, to petrochemicals factories, And it's quite an extensive directive, extremely important for regulating industry across Europe. It brought together 7 predecessor directives. So these were the IPPC directive, the Large Combustion Plant Directive, Waste Incineration, Solvents Emissions, and 3 directives on titanium dioxide. I know very little about titanium dioxide, but I'm glad it had 3 directives. It's going through a process of review at the moment. So now is an interesting time to thinking about the Industrial Emissions Directive. There was a Commission-led fitness check into it last year, and the full results of which have not yet been published, but they do inform the Commission's proposal for a new directive, which should be published, the proposal next year after some consultations on it this year. I think that will be a really important moment for looking at reform of the regulation of industry in Europe. So if it's something you're interested in, please contribute to the consultations and watch this space. The key features of the Industrial Emissions Directive. So it is primarily a directive that focuses on the permitting of industrial installations. And it takes an integrated approach to that permitting process. So what does that mean? What is an integrated approach? Well, it means that in principle, the permit should take into account the whole environmental performance of the plant or the installation that's being regulated, and not just focusing, for example, on one aspect of the environmental performance of that installation. So you bring together all of the emissions limits and so on relating to the different types of emissions and activities at the installation in a single place. Operation of installations under the Industrial Emissions Directive is intended to be based on the best available techniques. So the idea is that through regulation, you drive industry to apply the latest environmental performance standards to regulate pollution from the plant. And the emissions limits that are applied to the installation should be set by reference to what are known as the BATc AELs. That's a beautiful acronym which stands for Best Available Technique Associated Emissions Limits. So in other words, what are the emissions limits that can be achieved by applying these best available techniques? There is some flexibility to set slightly less strict emissions limits than what is the best available technique. And there's a derogation there, which Dominique and Regina will be talking about a lot more, which is what enables that. There are mandatory environmental inspections, which is obviously an important part of the enforcement regime. And for the purposes of this webinar, it's important to note that the IED aims to reflect the Aarhus rights. So they're specifically set out in articles, I think, 24 to 26 of the IED, reflecting provisions on access to justice, access to information, and public participation. However, unsurprisingly, it doesn't completely achieve what should be achieved to reflect the Aarhus rights, and clearly we'll be talking a bit about that as we go on. So what do we do with the IED? Well, firstly, we are engaged in advocacy, and when I say we, this isn't just Client Earth, this is the society, civil society, NGOs, and with an important role, very important role for the EEB, European Environmental Bureau, who lead a lot of the sort of advocacy level work around the IED, but there's a coalition of people working on it in this kind of way. So firstly, advocating for an effective IED, and so engaging in advocacy at Brussels level in particular to ensure that it should reflect, amongst other things, the Aarhus pillars. Secondly, ensuring correct transposition and implementation of the directive at the national level. We've seen numerous instances where the full requirements of the IED have not been properly transposed, or if transposed, have not been properly implemented. Examples of transposition failures include failure to reflect the requirements around best available techniques and so on. And examples of implementation failures include the failure to ensure that all the installations that should have permits do actually have permits. And clearly it's highly problematic if things are continuing to operate without permits, or if their permits don't reflect the IED requirements. And that means that one of the other things we've been focusing on, and this is very much what Dominique and Regina and others in our team and in our network have been doing, is focusing on the permit review procedure. So that's the procedure by which permits are, well, perhaps issued in the first place, but then subsequently updated to reflect developments in the best available techniques, so to reflect what is currently the best available technology, and also to reflect updated emissions limits which come into force, and other environmental laws which impact on the permitting process have to be reflected in updated permits. And a big part of what we've been doing is participating in the review of permits and then challenging permits where they are updated in a way where we believe that they fail to comply with legal requirements. And that's particularly the requirements of the Industrial Emissions Directive. And also there are ways that other bits of environmental law come into this as well. I think we talk a bit about that later. From our perspective as Client Earth, and for a lot of our partners, we've been doing this in quite a systematic way with respect to coal power plants. Clearly, coal plants, something we all want to move on if we can, as part of the energy transition, and due to their not only their climate impacts, but also their significant impacts on air quality, water quality, and so on. And that means that there are a huge number of issues to look at when you're looking at the permitting of coal plants. And that's been a very rich source of work for us. We've been supporting EEB in its advocacy it's been doing around industrial emissions and the IED in particular, and that has focused most recently on the fitness check that I mentioned last year and on the current process for updating the Industrial Emissions Directive. And then finally, we've been monitoring and intervening in cases brought by industry or member states in the Court of Justice, which are challenging aspects of the IED or challenging sort of implementing decisions which are implementing aspects of the IED. An example which I've referred to here is challenges brought by Poland and supported by Bulgaria, and also brought by the Coal Industry Association Eurocoal, together with some German coal companies, challenging the best available techniques conclusions which were adopted for coal plants and other large combustion plants in 2017. Yeah, so and actually, interestingly, there thinking about access to justice, well, Eurocoal could not secure its own access to justice because it was denied standing before the Court of Justice. And from our perspective, that was something we were happy to see. Although normally, of course, we support broad standing rights and admissibility. So that's a bit of background to the IED. And I'll move through these next slides fairly quickly on each slide. So, and the next few slides are all referring to specific articles within the IED, and some of them get relatively complex. What I want to do with this is, first of all, draw out kind of some of the key provisions which we might be focusing on in our litigation or in our advocacy work, and secondly, to demonstrate how, in my opinion, and the opinion of some others, the IED is not exceptionally clearly drafted and not well put together. One of the reasons for that, I think, is because it was this combination of 7 previous directives, and the way that they've been combined means that sometimes there are some obligations which appear a little bit maybe slightly contradictory with other things that are said elsewhere in the IED, or which don't fit together in the smooth way you would expect if a directive had been completely drafted from the very beginning by itself. So this is, in a way, one of the most important provisions in the Industrial Emissions Directive. And this is Article 11, where it sets out the general principles for how operators should operate. Why is it so important? It's important not because this is where you're always looking for the detailed regulation of industrial plants and so on. It's important because what it says there is really sort of setting the frame for all the other more detailed obligations that come after that. So what does Article 11 say? Well, firstly, importantly, all appropriate preventative measures should be taken against pollution. And that's quite a broad obligation, right? You would have thought. And also that best available techniques are applied, no significant pollution is caused, none, no significant pollution from any industrial installation. Wouldn't that be amazing? That's what it says, and I think we'll see when we get to the more detailed provisions, that's not really what you end up with, but it's a good principle to have. And then other, slightly more specific principles around preventing waste, using energy efficiently, preventing accidents and cleaning up the site and so on. And then from there on in, the directive starts getting more detailed. So Article 12 is a very detailed list of what information has to be included in permit applications. Article 13 sets out the process by which the best available technique reference documents are adopted. And so this is just something to spend a short period of time telling you about. So the IED itself contains in it a whole set of default rules around what are the emissions limits that must be applied to all sorts of industrial installations in the absence of any more detailed rules that may come later. So this is the European safety net found in the annexes to the IED with emissions limits and so on. But the way the IED is meant to work is that over time, the rules that are implemented get stricter. So that European safety net is the starting point for regulation, but not the end point. And the way we create these more detailed rules is through the adoption of best available technique reference documents and best available technique conclusions. And so the BAT conclusions are adopted every few years for each different sector regulated by the IED, and they contain strictly binding emissions limits. And they also contain very strong guidance over what technology should be used to ensure compliance with those emissions limits. And this forms the basis for a lot of the litigation that we're doing at the national level, and also for a lot of the advocacy that we're doing more broadly. So we, again, not just Client Earth, but more specifically EEB, our close partner, is very heavily involved in the advocacy work around what should be included in these BAT conclusions, and the BREF, the BAT reference document, that is kind of a guidebook to the BAT conclusions. And this process is regulated under Article 13. So that's what this article is about. I won't spend any longer on that, but because the phrase BAT conclusions and BREF come up all the time in the context of the IED, it's really important to understand that that is where every few years we are updating the emissions limits and the technologies that should be used. This is an example of an extract from the BAT conclusion document. So why am I showing you this? I'm showing you this because this is law. This BAT conclusion document is containing legal provisions that have to be applied in permits and enforced in the courts. Now, this is one small table from one of the many BAT conclusion documents containing, in this case, the rules for emissions to air from combustion of coal or lignite, and specifically here we're looking at SO2. And as you can see, it's quite a detailed set of standards which apply with a whole bunch of footnotes. This is typical. This is what the BAT conclusions look like throughout. This is what the IED annexes that provide the European safety net values also look like throughout. From one perspective, it's clear. There are clear numbers. You can read across in the table. You can go, well, this means that, and this means that. But the complexity comes when you look at this from an access to justice perspective, and indeed from a public participation and access to information perspective. This kind of documentation is really difficult for people who are not experts to understand. And I've been working on large combustion plant BAT conclusions for a number of years now. I find them very difficult to understand if it's not a very specific point I've already looked at before. You have to cross-reference a lot of different things. You have to look up a lot of defined terms. And even then, due to the way everything has been drafted, there can still be vagueness, lack of clarity, some things which are just not properly defined, and so on. And this causes a lot of challenges, challenges at the public participation stage, when the public want to say, well, this is the standard that should be complied with, this is why it should be complied with. But if you have to read hundreds of pages of documentation, which sometimes you do if you want to look to the reference documents, the BREF, in order to understand what the BAT conclusions say, that's not something that the average member of the public is going to find particularly straightforward. It's not like opening your criminal law and saying you can or can't do this. And the same problem we have encountered with judges. They face the same difficulty. The IED is so complex in its drafting that typically we found judges are struggling to really understand the detail of the obligations that exist under the IED. And that means that they tend to show quite a lot of deference to the public authorities that are making decisions on permits and so on. So this example extract from a BAT conclusion document is meant to demonstrate that fact. And it starts getting complex as well in the main body of the IED. So Article 14 of the IED, this sets out everything that should be included in permits. So at a high level, seems pretty clear and straightforward, right? So you have to have emissions limits for all the Annex 2 substances, and that's all the kind of pollutants you'd expect to have emissions limits. You have to have appropriate measures for protecting soil and groundwater and waste management. You have to have suitable emissions monitoring and annual reporting. And there have to be some provisions minimizing long distance or transboundary pollution. Transboundary pollution. So then it goes on. The BAT conclusions are the reference point for setting permit conditions. Well, that's good. Great that the BAT conclusions are the reference point. The BAT conclusions have, the strictest set of rules that have currently been published. But what does it mean for them to be the reference point? Does it mean they have to be strictly complied with? Perhaps not, because it says they're the reference point. It doesn't say that they are strictly binding. Does it mean they can be completely ignored? Well, clearly not. They have to be the reference point. But what does that actually mean in terms of a binding obligation on permit writers that can be enforced in court? I don't know. And it's difficult to litigate around that point. And it's also difficult at public participation stage. Again, there's examples of different technologies in the BAT conclusions, but how firmly can you say they have to be followed? It's a difficult question. Then it goes on to say that the authority may set stricter permit conditions in the BAT conclusions. That's great, very clear, no objections to that. It's not an obligation, it's permission, that's fine. And then it also contains various rules for how you set permit conditions where there is not yet adopted a relevant BAT conclusion document. And other provisions go on to have more details around monitoring requirements and so on, which we won't dwell on here. But then the complexity increases further. So Article 15 of the IED sets out the rules on emissions limits. And in a sense, the rules are clear. So once you have a BAT conclusion document, once that's been published, the emissions limits in a BAT conclusion document, you can see here, and you can see that if you look at what we say for Article 15.3, emissions limit values, ELVs, are to be set to ensure emissions do not exceed emissions associated with best available technique conclusions as laid down in the BATc. Now that's the BATAELs I mentioned right at the beginning. Your emissions limits can't exceed what is in the BATc. Very clear, good. Now let's go back to the slide where we had the extract from the BATc. What you'll see from this is that a lot of the emissions limits are expressed as ranges. So let's take the example of an existing coal plant of more than 300 thermal megawatts in a pulverized coal boiler, using a pulverized coal boiler. So that's, you can read across on that. I don't know if you can see it, but anyway, I can. And what that says is that there's a range. The BATAEL is a range from 10 to 130. So the permissible limit that may be set is anywhere between 10 and 130. And in fact, because they can set stricter permit conditions that they want, it could be less than 10. But the range there is 10 to 130. So the obligation that we saw in Article 15.3 is to set an emissions limit which does not exceed that range. Well, that's great, but what about the range? What about between 10 and 130? Where should it be set in that range? There's no strict legal guidance around that. And that causes a lot of problems again, where plants are using technology that can clearly be used in a way that could result in a much lower value being complied with in that range. But in reality, the permit sets a much higher emissions limit. What to do in that situation? Not clear. And that poses issues for public participation and access to justice. So there's a lot more that we could unpack in Article 15, which I won't because that's not the purpose of this webinar, and I only have 5 minutes left, and I don't want to bore everyone. So looking at the issues in access to justice in a bit more detail. So Articles 24 to 26 set out the Aarhus rights, and just looking quickly at Article 24, because it is relevant for access to justice, even though it covers information and public participation. Article 24 requires public participation to take place in a number of instances. So this includes permits for new installations, where there are substantial changes to existing installations. Now, substantial change is a defined term, and it includes where you are leading to more pollution effectively coming from the installation. So no public participation required if you're going through a process that will lead to less pollution. And that's an important point, which we'll come back to. Public participation also required for Article 15.4 derogations, which Regina and Dominique will talk about, and also where there is such significant pollution from a plant that the permit needs to be updated. So that's where public participation is required. Now, if we look at Article 25, and I did include the full text bit here, and I realize that's probably not something you want to read right now, but I think the important thing to note is this access to justice provision very closely mirrors the Aarhus Convention access to justice provision. And in doing so, it refers back to Article 24, where we saw the public participation rights. Now, you'll recall that as I said, public participation rights are not afforded to all types of decision regarding permit making, and that has knock-on effects from an access to justice perspective. So what do we see are the main access to justice obstacles when we're trying to enforce these complex IED obligations in national courts? Firstly, non-national NGOs are not typically granted standing. I imagine this is a problem that arises not just in the IED context, but also in other contexts. But it seems particularly problematic in the IED context, because if you look at, for example, a coal plant or a refinery or anything with a large chimney emitting pollutants, those chimneys are built specifically in order to disperse emissions from the plant a very long way, ideally into other countries, away from where the plant is built. But if NGOs and indeed individuals and others from other countries struggle to secure standing in disputes around permits, that clearly appears to be inconsistent with the idea that there is a lot of pollution moving on a transboundary basis. Secondly, the scope of Article 25 raises some issues. So as mentioned, it covers the decisions, acts, or omissions which are subject to Article 24. And Article 24 is the public participation provision, which, as we noted, doesn't provide a fully comprehensive list. But the main issues that we see with respect to the scope concern omissions. So normally, there is a way to challenge in court a decision of a public authority to issue a permit or something similar to that. Where we struggle to secure access to justice is where there are omissions by the authority. So that might be in particular around enforcement or monitoring or imposing penalties on operators. Where that is not done in the right way, it can be very difficult to find a way to challenge that in national courts. And that appears to be in contradiction of what is intended in the Aarhus Convention in, I think it's Article 9.3, and Sebastian will correct me if I've got that wrong, where emissions of that nature should clearly be able to be challenged in national courts. And there's another sort of related issue, which is with Article 79 of the IED, which is the penalties clause. So that requires, as often in EU law, penalties to be effective, proportionate, and dissuasive. When our experience, penalties in many countries for non-compliance with the IED are not effective, not proportionate, and not dissuasive. And the best example that we have of that is in Romania, where a number of coal plants operated for a very long period of time with no permit whatsoever after Romania joined the EU, and when it was subject to these permitting requirements. And a coal plant operating and generating revenues of potentially hundreds of millions in a given year, subject to a maximum fine of 3,000 euros for not having a permit, and then it can just carry on operating. So that is clearly not effective, proportionate, dissuasive, but it's very hard for us to do anything about that. There is no access to justice in that context, no way of compelling stricter remedies, stricter penalties to be imposed. And then the other issue we have, so Article 25 requires access to justice to be fair and equitable and timely and not prohibitively expensive. And I think there are ways in which each of those elements are not complied with. And so firstly, as mentioned, everything is extremely technical and the proceedings are normally very technical. Not only is it hard for judges to understand what's going on, or even for the lawyers representing the NGOs to understand sometimes what is going on, but we have to hire technical experts to present this evidence to the court, and indeed sometimes to explain it to us as well. And it is extremely difficult to find technical experts. Most of them are engaged by industry. The people who really know what's going on inside a coal plant work for coal plant operators, and they're not going to be very willing to work for us. That has been our experience. Very hard to pin them down. And if we have been able to secure people, they can be extremely expensive to work with. So whilst often when we think about access to justice, we think about making sure everyone has a lawyer to represent their case, it's equally important to make sure they have the technical experts that they need to be able to represent their case. And that's what's so often lacking and just too expensive for NGOs or individuals to afford. And that's also an issue at the public participation phase. I've already mentioned issues for judges and lawyers. The timing around challenges can be really problematic. In some countries, there is a really long period of time to bring a challenge to a permit decision. I think in Romania, it's something like 6 months, but in Bulgaria, it is 2 weeks. And whilst there's always the possibility of supplementing your arguments at a later stage, reviewing a permit in sufficient detail in a 2-week period, that's a full-time job. And even doing that on a full-time basis, if you don't have a technical expert, again, it's really hard to reach any firm conclusions. So timing can be a real issue, and those timing issues are often exacerbated by the poor access to information practices that relate to the IED. Most countries do not have a very good system for putting all the permit information and all the emissions information and all this kind of thing in one place where you can see it all and easily understand what's going on. Some countries get it right. I think Ireland is probably the best, but most really do not. And without that information, it can be very hard to determine what sort of legal challenge, if any, might be appropriate. There's similar problems around public participation. I already mentioned this, and there's actually been a procedure before the Aarhus Convention Compliance Committee brought by one of our very good partners, IDMA, who are based in Spain, and where I think the advanced draft final findings or something like that of the committee have been published, which condemn the way the IED has been drafted and note that it violates Aarhus requirements regarding public participation because it doesn't require public participation in contexts where you might be imposing stricter environmental standards. Why do you need public participation in that context? Well, how much stricter should they be? A little bit stricter or a lot stricter? That is of interest to the public, and so there should be public participation there, and that's what the committee has found. And finally, there's very few relevant Court of Justice judgments or indeed national court precedents on the IED. That makes it hard to find authoritative interpretations of a lot of provisions. It's a bit of a chicken and egg situation there. And probably the reason why there's so few cases is because there's such high barriers to access to justice. But without those precedents being set, it can be very hard to have the confidence to bring a case in the first place, and it's very hard for judges to look for guidance as to how this thing should be implemented. I did have a slide on building an IED case. I think probably it is better that in light of the time I move on from that, and I think most of these issues either I've already touched upon or my colleagues will touch upon going forwards. That slide probably shouldn't be there. It just should say thank you, shouldn't say sorry. Sorry for the complexity and what's gone before. And I think now I hand over to my colleagues. Thank you.
Hello everyone, my name is Dominique Doyle and I am an environmental lawyer in our coal team. So our program that Sam is a part of, we work in many different countries across Europe. We work with local NGOs and local lawyers, and we develop legal strategies and take cases to basically help governments and corporations move away from fossil fuels and into cleaner forms of energy. So today we're going to talk about a really exciting case that we're in the middle of in Bulgaria. In Bulgaria, we work with local NGOs. So we work with Zazamiata. This is Friends of the Earth Bulgaria. And we also work with Greenpeace Bulgaria. And we also work with local lawyers, fantastic local lawyers. And Regina Stoilova, she's with us today. And we're going to be, she's going to be talking about the case with me. So today we're going to talk to you about a case that we're taking against the coal power plant Maritsa East 2. Let me first start by introducing you to the plant. So Maritsa East 2. It is the biggest thermal power plant in the Balkan region. It's quite old. It began construction in 1962 to 1964. It uses local lignite with a high sulfur content. Now, this is important because it's particularly polluting, the type of this lignite. It's also a state-owned plant, so it's owned by the state-owned company Bulgarian Energy Holdings. Also, the coal that is used in this plant comes from Maritsa East mines. Now, these mines are continually expanding, and over the next few years, they will lead to, this expansion will lead to the expropriation of at least 3 more villages. So really, it's a hungry coal plant. It's very polluting, and this next slide just shows you, it's a bit of an example of how polluting it is. So a report came out in 2018 that measured the most polluting companies in the EU, the most polluting companies from a coal perspective. So Bulgarian Energy Holdings came 10th on that list, so it's the 10th most polluting company in the EU. And what's interesting is that it's the 10th most polluting company from this asset alone, so from Maritsa East 2 alone. So for example, other companies were on this list like RWE in Germany and PGE in Poland that have tens of coal plants. But we have here Maritsa East 2 scoring the place of BATc just through this asset. So just to give a refresh on the legal provisions, I think Sam just went through them, that are the basis of this case. So Article 21 basically says that all coal plants across the EU have to update their permits before August 2021 to include these really new strict emissions limits for coal plants. So they have to comply with these very strict emissions limits, and they need to install really sometimes expensive pollution abatement technology, so technology that's going to stop or reduce the pollution. And if they can't do this, then they need to shut down. So, of course, there is an exception to this rule. there is an exception to applying these really strict emissions limits, and it's contained in Article 15. I'll just read you out Article 15 because it is the entire basis of our case. So let's get familiar with it. So Article 15 says that the competent authority in specific cases can set less strict emissions limits only where an assessment, this is important because it involves an assessment shows that the achievement of these really strict emissions limits would lead to disproportionately higher costs compared to the environmental benefits due to the geographical location or local environmental conditions of the installation or the technical characteristic of the installations. So basically it's saying that the authority can set less strict emissions limits where we have an assessment that shows that reaching these limits will be disproportionately expensive compared to the environmental benefits that we would achieve if the plant were to comply with the emissions limits. So, as we expected, the Bulgarian authorities granted Maritsa East 2 an indefinite derogation. This was the very first derogation that has been granted to any plant in the EU, and it's the first derogation to be challenged. So we're really dealing with something that's novel, it's entirely new territory. So this little table here, I apologize for the technical nature of it, but Sam did warn you. This table outlines the basis of the derogation. So the plant has been allowed to derogate from sulfur dioxide limits and mercury limits. So this column in the middle, the LCP BAT conclusion column, so this is the law. This is what the new limits are for all coal plants. So the new limits are 10 to 130 milligrams per cubic meter, but in the case of plants firing indigenous lignite, so this is actually the case of Maritsa East 2, so they've got a specific indigenous lignite underneath them with a really high sulfur content that I mentioned. So the emissions limit there is 320 milligrams per cubic meter. Now the plant wants to emit 570 milligrams per cubic meter. So that's almost double the amount. And for mercury, the new emissions limit in the law is 1 to 7 micrograms per cubic meter. And Maritsa East 2 says that they want to emit 30. So this is almost 4 times what is allowed under the law. So this is a huge derogation. And when we're thinking about the time that this plant wants to emit this derogation, it's indefinitely. We've just seen some plants in the Czech Republic apply for derogations, but they've only applied for it for a few years, so that they can actually do something about it in a few years, whereas this plant intends to do nothing. So just to help you visualize what this means, because it's very difficult to understand what's going on from all of these numbers, unless you've studied science. I see someone in the comments has. That's very good. So these images help us visualize what's actually going on. So we had an expert do up some modeling for us to show us what the spread of the pollution would look like if the plant were to comply with the law versus what it would look like if the plant didn't comply with the law and was granted the derogation. So on the image to the left, we have what you can see as the spread of pollution inside Bulgaria, and it's spreading to different territories. They're the lines on the map. If the plant were to be granted this derogation. And on the image to the right, we have what the pollution would look like, the SO2 pollution would look like if the plant were to comply with the new strict emissions limits. Now, this second slide shows the massive secondary pollution that is caused by the SO2 derogation. What happens when SO2 is released into the atmosphere is that it combines with other chemical compounds and it forms secondary pollution. Now, this secondary pollution is PM 2.5. You may have heard of it. It's a very fine particulate matter, and it's extremely harmful to human health. It enters the lungs, and it's very damaging. So on the left, you'll see what the plant wants to do, and then on the right, you'll see what it would look like if the plant were to comply with the law. And similarly, this is the image for mercury. So on the left, we have what the spread of mercury pollution would look like if the plant were to be granted a derogation. And on the right, we have what the pollution would look like if the plant were to comply with the law. So we, when I say we in this context, I mean our project. So the local NGO in this case is Zasmiata and Greenpeace, and they filed a complaint against this. And we also had a Greek individual and a Greek NGO, the Green Tank. They also joined the case as interested party. And I'll take you through that process in a minute. Currently, the case is still ongoing, so we have our final hearing next week, and this will be open to appeal as well. So everything that I'm going to say and that we're going to say today, we're going to say that we allege that this happened because the case hasn't been finalized. So the legal grounds that we pursued were as follows. We allege that there were failures in the public consultation. We also allege that there was an incorrect application of Article 15.4, so that key provision that allows plants to derogate from the new limits. And we also allege a violation of Article 18, which we will go through in a minute. So firstly, failures in the public consultation. We allege that the public was not informed early in the procedure for the taking of a decision. So this was such a complicated procedure. To grant a derogation like this requires a huge amount of technical information. It's not like other normal permit procedures. And what happened here was the public consultation was held at the very end of the permit update procedure, only for 1 month. And I think we got access to the documents 14 days into that 1 month. So we only actually could, we were consulted for 1 month. And then a final decision was taken 1 month later. We also alleged that there were no access to the documents relevant for the decision making. So the essential relevant document in this case was the cost benefit assessment. So this was the assessment that was key, that would show that the cost of updating the plant was disproportionate compared to the environmental benefits. So basically, at no point during the permit update consultation was the cost benefit assessment disclosed to us. We had no idea what was in this assessment. And when the permit was issued, still the cost benefit assessment was not attached to the permit. So we had no understanding of what basis the authority was going to allow this huge power plant to emit double and 4 times the level of toxic emissions for an indefinite period of time. And it was only after we had brought the legal challenge that Regina and our partners were in court that the judge actually ordered the cost benefit assessment to be disclosed to us so that we could see on what basis they had allowed this decision. So this was a huge access to information burden. In Bulgaria, we've experienced massive access to information hurdles. We anticipated this, in fact, and we asked for the cost benefit assessment even before the permit update had been issued. We knew that it was going to be a massive barrier, so we actually took 2 court cases to try and get access to this document, one of which we won. We argued that this document was environmental information based on the Aarhus Convention, and the judge said that, ruled in our favor, said the information should be disclosed. This went back to the authority and they still refused to disclose it. So a lot of the battle, even before we were able to challenge the decision, was actually getting the information we needed to understand what was happening. Also, something that's very interesting is that we also alleged that the public in neighboring states, so Greece, the public in Greece, were not consulted. So I'll go into this in a little bit more detail just because it's quite interesting. As a result of the modelling that we did, so you can see a picture of the modelling, some of the modelling we had done on the right, we discovered that the derogation decision, so this decision that has been granted to Maritsa East 2, would have what we thought were significant impacts on the territory of northern Greece. For example, our modelling showed that the derogation decision would result in approximately 500 premature deaths in northern Greece over a 10-year period due to high levels of pollution. So you can see on the image the little green X that shows you where Greece is on the map, and you can see that the pollution actually travels down through Greece. When a permit is updated in accordance with Article 15.4, so in accordance with this provision, as is the case here, the IED says that the public concerned must be given early and effective opportunities to participate. Under the Aarhus Convention, the members of the public must be able to participate in decision-making and have access to justice in environmental matters without discrimination as to their location or the centre of their activities. So, although Green Tank and the Greek individual who lived in these northern territories of Greece, although they are both an environmental NGO registered in Greece and a Greek citizen, they argued that due to the damage that was occurring in Greece, they were the public concerned. And they joined the case as interested party, and they were accepted to join the case as interested party. So this was really, this was a very positive development. Also, Green Tank relied on the ESPU Convention, which is a convention on the environmental impact assessment in a transboundary context. So this convention obligates the state where a proposed activity is planned, so in this case Bulgaria, to notify parties likely to be affected by transboundary impacts of that activity. So Greece. This is a new approach that we're exploring. The ESPU Convention is historically used in cases where there's almost a well understood risk of transboundary harm. So for example, you'll have a nuclear reactor on one side of the border in one country, and this would pose a significant threat to a neighbouring country, for example, if there were to be a disaster at that nuclear reactor. And in that case, the two countries would need to consult each other about that risk. Also, for example, where there are highways and pipelines that cross borders, the same thing needs to happen. These countries need to consult each other. However, in light of new scientific studies on the severe impact of secondary pollution, so PM 2.5 pollution, that travels across borders, especially from coal plants, we wanted to explore these new developments using the ESPU Convention and transboundary pollution. So really what we've seen through these studies is this invisible pollution become very visible. And I will let Regina go through the remaining grounds. Thank you.
Thank you, Dominic, and hello to our audience. My name is Regina Stoilova, and I am one of the lawyers that had the chance to bring this really interesting case before Bulgarian courts. Dominic already explained the first ground that we claimed was violated in the issue of the derogation to Maritsa East 2 case, and I will explain the other two. So secondly, we claimed that the derogation permit of Maritsa East 2 was issued in violation of the core principle on which such derogations are issued, basically that it violated Article 15.4. Just a quick refresher, Article 15.4 says that less strict Here it is. Article 15.4 says that less strict emission limit values may be set where the costs for a power plant to reach the emission limit values under the BAT conclusion are disproportionately higher compared to the environmental benefits. So in a nutshell here, we have to compare costs and benefits. When we say costs, let's come back to my slide. Here we are. So when we say costs, we actually mean the investment that an operator needs to do in order to improve the installation so that the emission limit values under the BAT conclusions are met. And when we say benefits, we mean the health benefits and the environmental benefits. So we mean the reduced number of premature deaths, the reduced number of hospitalizations due to air pollution, and we also mean improvements to the ecosystems and materials, buildings, for example. So these have to be assessed, calculated, and compared. And obviously, this is not an easy task. In the case of Maritsa East 2, a consultant concluded that the abatement cost for the plant to reach the emission limit values under the BAT conclusion amounts to almost 116 million euro. But when it came to the benefits, the consultant used two types of approaches to monetize the environmental benefits. And they came with really different results under the two approaches. Under the approach called impact pathway, the consultant calculated that the benefits would amount to a bit over 6 million euro, whereas under the other approach, damage cost approach, the result was 724.7 million euros. So you could see how big the difference is, the difference between the two results is, whereas the benefits under the damage cost approach are more than 100 times higher than those under the impact pathway. And which one do you choose? Do you think that Bulgarian authorities considered as the right ones? We did give you a hint here. So these are the benefits under the impact pathway approach. So Bulgarian authorities simply compared the costs with this really low number of benefits, and they came to the conclusion that the costs are obviously disproportionately higher. But what are the reasons for this really big difference in the results of the two methodologies? When we finally got our hands on the cost-benefit assessment, we saw that two key failures were made in the impact pathway methodology, and we claimed that before Bulgarian court. First of all, secondary pollution from the power plant was not assessed and calculated. And here on the picture, you could see how secondary pollution from sulfur dioxide of Maritsa East 2 looks like in the case of the derogation scenario. Secondary pollution comes when sulfur dioxide emitted from the power plant react in the air with other chemical compounds, and it creates the particulate matter 2.5. I guess most of you have heard about particulate matter 2.5. It is a lot has been discussed now about it and how dangerous it is to human health. Scientists more and more warn that there is no safe threshold, and even exposure to very low amounts of this pollutant could lead to health damage. Nonetheless, in our case, this pollution was not calculated in the final result of the environmental benefits. Also, the low number of 6.2 million euro of environmental benefits includes only benefits in an area of 45 kilometers away from the plant, meaning a really small area, and we could see that no pollution in neighboring countries and whatsoever has been taken into consideration. So we allege that this is the main reason why the results under the impact pathway approach were so low, and that if actually the results under the other methodologies were taken into consideration, then the outcome of this comparison between costs and benefits would have been different, and derogation should not have been granted in the first place. We also claimed that Bulgarian authorities failed to apply Article 18 correctly. Article 18 is very interesting article in the ID because it does make the link between the Industrial Emissions Directive and other bodies of environmental law in the EU that set environmental quality standards. For example, when we say environmental quality standards, we mean air quality standards or aims for water bodies. And it is really important to make the link between these different bodies of law, because when we set the conditions under which a power plant is to operate, obviously it may have significant impact on the air and on the water. And Article 18 requires that if an environmental quality standard is to be violated, then additional measures are to be added in the permit itself. In the case of Maritsa East 2, we looked at the nearby town of Golubovo, which is about 20-25 kilometers from the power plant, and interestingly is the only place in the European Union where the air quality standards for sulfur dioxide are still exceeded. Unluckily, the people from Golubovo live near the 4 biggest coal power plants in Bulgaria, and as we said, Maritsa East 2 is the biggest of them. So very often they face exceedance of the air quality standards for sulfur dioxide. You could see in these two charts. The chart to your left shows the number of exceedances of the hourly standard for sulfur dioxide, and the one to your right says the number of exceedances of the daily standard. You could see that while there was some decrease in the exceedances in 2018, in 2019, again, we have rise in the exceedances. And actually, just a few months ago, the European Commission started an infringement procedure against Bulgaria for failure to comply with the air quality standards in Golubovo. So basically, our allegation here was that when Bulgarian authorities issued the permit of Maritsa East 2, they failed to comply with Article 18 because they did not include additional measures to secure compliance with the air quality standards in the nearby town of Golubovo. And basically, we saw this really big derogation that allowed the power plant to emit twice the emission limit value under the BATc conclusions. In a nutshell, we listed our claims, but to be successful in court, we have to prove them. So we have to prove that what we say is correct. We have to prove that Maritsa East 2 has emissions that go beyond the 45th kilometer, that these emissions reach Greece, that the air quality standards in Golubovo are violated, and the power plant contributes to this violation. How we prove that before court? Interestingly, we decided to do our own modeling to calculate how the concentrations of emissions from the power plant and how far they reach. The pictures of the pollution from Maritsa East 2 were actually part of this modeling that we did. We also had the author of this modeling being heard by the court as a witness. Unfortunately, in Bulgaria, we are procedurally restricted and we cannot have our own expert witnesses. So the author of this excellent modeling was heard only as a witness. Basically, he could not, his evidence could not be credited as expert evidence. This is what means in practice. So we also have had court-appointed experts. So these were experts that the court chose to appoint, and these are usually national experts. It is really not happening to have international ones, which is a big barrier, which I would mention later on. And of course, we submitted documents to prove our case. As I already mentioned, Dominic and Sam already mentioned some of the barriers that we have with applying the Industrial Emissions Directive in practice. But when you go on the ground, you see how these barriers could really be problematic to proving your case. I would mention a few of the key barriers that we face and that we try to work around. First of all, as many times mentioned already, the issues we had to present to the court were very technical, both from legal side, but also from factual side. So we have to present these really technical and scientific issues, explain them to the court, and also prove them to the court. This was especially problematic in the area because we had to prove what science says. As you might expect, science is not unified voice. So we actually had experts that prepared the cost benefit analysis, and they did it in certain ways. So we had to disprove that this is not the right way to do it by having other scientists saying something else. So this is a very difficult situation where you have to explain to court what is the right way to do science. And as you might expect, the judge is not does not comprehend science very, very well. We actually had the judge in our case so many times, really honestly, saying it is really difficult to understand what you guys talking about. And another barrier we faced is that this is specific to Bulgaria, but it could be in other countries as well. Technical facts had to be proved through the experts appointed by court. And we faced really difficult situations because national experts, obviously, they did not have experience with this cost benefit analysis. So they were not aware of the new methodologies that we claimed had to be applied in the specific case. Also, in case of Bulgaria, we faced difficulties with independence of experts. What is next on this case? We are almost through with our first court instance. We would have one more hearing in the end of July, and we expect a court decision by the end of the summer. If we are not happy with this decision, we could take it to the Supreme Administrative Court. So this was the case of Marica Istu in a nutshell. If you have some questions or something that was not clear, I'll be really happy to answer it. And over to Sebastian for questions.
Yes, hello. Thank you all very much for these very, very interesting presentations. Apologies to the participants that we went a little bit over time today. Sam, as you may have seen, Sam has already taken the step of replying to some of your questions. And there's still some that are open that I will look at in a moment, but just in case you are out of time right now, I'm already giving you here the reference to the other material in our project. On the one hand, we have written a guide on access to justice that you can access on our website. And here's also the links to all the previous webinars. And we will circulate these slides to you after the webinars, so you can then just click on it. And of course, always feel free to send us an email if you have any other questions, in case you have to leave now for another appointment. If not, if you still have a few minutes, I will have a quick look at the questions that are still here. We have on the one hand here a question that has not been answered yet, that is from Jeremy Walters. That relates to the EAA cost-benefit analysis, which is, I think, something that Regina had talked about. And it says if whether we are satisfied with authorities using standard costs of harm figures, so cost per ton or kilo released. Maybe, Regina, do you want to say something on that first? But then maybe Sam or Dominique would like to add something too.
Sure. So this is the question from Jeremy Walters, who asks if there are recognized ways to estimate the secondary pollution, right?
You can start with that one too.
Okay, I will start with this one if that's okay. Yeah, actually, there are such models, and the model that we used in our specific case to do to calculate the emissions from the power plant was exactly this type of model. The model we used was called CalPUF, and all these beautiful pictures you see from the pollution coming from the plant are made with this model. There are other technical models to measure secondary pollution that could be used. But yes, there are. But just the problem that we faced was that the court-appointed expert in our case were not familiar with these models, and they basically confirmed that measuring secondary pollution is very, very difficult task. So they put us in a very difficult position to have to persuade the court that actually there are such models and how they work.
Thank you very much, Regina. I will go in this order then, instead of the reverse order I had just proposed. This was not a good idea. The second question we have here is from Miriam Masiani, who asks if you're considering to using information collect from national control bodies in order to save time on reviewing the overall situation quickly. I believe that is the situation that we've used in this case. Perhaps you want to explain a bit more on how you've done that, maybe starting with Dominique.
I think what Miriam is asking is whether we use information collected by the authorities, such as monitoring data, and we do that. We use lots of monitoring data that's collected by the national authorities that's reported to an EU database called the EU Pollution Control Register, and it does save time. Not all countries collect information and report properly, but I think we would like this to be a quicker experience. But yes, we do that.
Yeah, I could say that we use officially available data a lot.
Thank you very much for those for these replies. Then to the question that I have already mentioned by Jeremy Walters, if we are satisfied with our authorities using standard cost of harm figures, so cost per ton occurrently released, which are published by the European Environment Agency in the cost-benefit analysis. So maybe, Regina, you can talk about that.
Yeah, actually, when I manage the damage cost approach, this is exactly this type of approach. And in the case of Maurice too, the consultant used especially this this approach under the and the number, the calculated environmental benefit per ton of reduced sulfur dioxide, and that's how they got this really big number. And if they've taken into consideration this result only, no derogation for sulfur dioxide should have been granted. The difference between the damage cost approach and the impact pathway approach is that where the damage cost approach, we have a standardized standardized environmental benefits allocated per a ton of reduced emissions. In the case of the impact pathway approach, you make the whole exercise for the specific power plant. But we could see, whereas this could be much better in theory, it actually gives a lot more discretion to the consultant, and they could avoid or not calculate certain benefits. If anybody else, Dominic or Sam, want to add something to this?
I have a feeling Sebastian has frozen somewhat. If Sebastian isn't there, maybe I just draw attention to a comment that George posted in the chat just now. So not in the question list, but in the chat, where he says Article 15.4 does not require a cost-benefit assessment. It requires a comparison of some sort of benefits and costs. The assumption that this has to be a CBA is leading invariably to an underestimation of benefits, which plays into the hands of operators and authorities. Not to mention the fact that this turns Article 15.4 into an econometric exercise. Personally, I completely agree with that. You're trying to measure two incommensurable things. You're trying to measure financial costs borne by an industrial operator against environmental and health costs, which are not strictly financial things, but which there is some methodologies that have been produced to try and turn them into financial concepts. But the financialization of health and environmental welfare is clearly a challenging process, shall we say, and I think very problematic when you look at Article 15.4. I don't know, Dominique or Pina, if you want to say anything on that. Seems like they don't. Before we just answer the most latest question, again from Miriam, there's just a few of the earlier questions that I answered in writing that I would like to draw attention to because I thought they were sort of particularly important points. One of the questions is typed by Paul, but says it's from Jeremy, where it says, do you think the focus of the IED on point source emissions is limited? Should the investment required to meet the IED standards be utilised to achieve the best environmental outcome rather than a reduction in emission concentration where there is little benefit? We completely agree with that. And that's something we would love to see come out of the process for adopting a new Industrial Emissions Directive. This emphasis on reducing emissions from a chosen technology. Clearly, if a technology is to be used, yes, you want the emissions to be limited as much as possible, but much better to choose a less polluting technology in the first place. And there's all sorts of examples where this could apply. The most obvious one to say is, well, if you're going to generate power, before thinking about how to reduce your dust emissions from your coal plant, why don't you build solar panels instead? And that kind of approach systemically is clearly the direction we would want to see things go from an environmental perspective. There was another question about the ranges in the BAT conclusion document. So on the example I gave earlier, there was a range between 10 and 130. And the question, which I've never really actually thought about before, but it's clearly, you know, a good point. Why is there a bottom of the range? why 10? Why not 0? And the question was, is that to try and ensure a level playing field between member states to stop people having even stricter emissions limits than other states for some reason? I don't think that's what it is. I think it's because the BAT-AEL range of emissions limits is meant to reflect the achievable emissions limits using the technologies which are listed in the BAT conclusions. So I think that the idea there would be 10 is probably the best you can achieve using those technologies. But Article 14 of the ID anyway lets the authorities set a stricter emissions limit if they want to.
And just to add to that, there is this range, so there's 10 to 130, but there are other ranges in the IED. And we have tried to argue in some of our cases that a power plant should set the range at the lower end. So they should set their emissions limits towards the 10 and not towards the 130. But it's very difficult to argue this because so they've set this range, but they haven't required any legally binding obligations to comply with any limit in that range. So what we see across the EU is that power plants uniformly set their emissions limits at the very top of the range, whereas we actually think they can comply with the lower end based on technical advice. So although there is this range, we wish that we could legally enforce it towards the lower end.
I had some internet connection problems, but I see that you have done very well in covering while I haven't been there. We had some other questions come in the meantime as well. Unless there's another question from down below, Sam, that you would like to flag first. Is there one? No?
Just keep going, Sebastian, it's fine.
Okay. So the top question on the list right now is again from Miriam. How do you prioritize? What is the methodology in starting? I think the question here is, what is the kind of cases we focus on? And how we prioritize the cases that we want to bring or the kind of issues that we want to address. Perhaps that is something for the lead of the team. So I'm going to pass that to Sam.
So our team has the name Coal Team, and that gives away a lot of the answer. We are set up to focus mainly on coal. Coal is very easy to prioritize, though. It's the worst climate impacts, it's the worst air quality impacts most of the time, and so on. So, and you know, when we're looking at where to focus our work around coal, again, we're clearly looking for the the ways we can have the biggest impact on the efforts being made to phase out coal. That might not always be the easiest court case to bring that we focus on. Maybe it's the most strategic one for some other reason that we focus on it. I guess that's the high-level answer to that question.
Very good, thank you. And then we have a question from Belinda asking what is the last hearing about in the case, and if there is a possibility that something unexpected will happen. Would pass that one to Regina.
Well, we did get one more hearing just because the other parties had presented some data we haven't looked at. And in Bulgaria, if you didn't have the chance to get acquainted with the evidence, you are provided more time for that. We don't really expect anything different from what we presented so far. So I guess we would be just looking at the court decision in the next months.
Okay, thank you very much. And then I think that's the last question that has not been answered yet, is relating to changes in technology in relation in particular to fine particles and the virus, and how we can be proactive and how can technical experts be involved. I guess how they can inform our litigation further. Maybe, do you want to say something? Yes, Dominic, you're already raising your hand.
That's okay. I've just seen that there's a question about the definition of the term significant pollution. Sam has answered this. There is no definition of significant pollution in the IED, but there is useful case law on the definition of significant pollution in the context of the Environmental Impact Assessment Directive. So we can look at the definition to help us. I think the Vardense case is particularly useful in that respect, taking in light with the precautionary principle, where significant pollution would be a risk that cannot be excluded on the basis of objective information. So we take that approach to what we consider significant pollution.
Thank you very much. I have another question here, which is, what will be the result of the court case if we win? Will the plant be forced to close, or is there a window to comply? Maybe giving that to Regina again.
Yeah, so if we are successful, and we do hope we are, this would mean that Maritsa IS2 should either comply with the best available techniques and the emission limit values, or they would have to close down, or they could, of course, make the necessary investments. So in both cases, because we've had quite a lot of allegations here in Bulgaria that we want to close the plant down, which would have detrimental, I would say in inverted commas, consequences for the region. But what we really want to see is we want to see the law being applied, and we don't want to see that derogations become a possibility for every plant to continue to operate the way they do right now.
And I think, sorry, just to add to that, one of the reasons we take these cases is to force the government to actually come up with a transition plan. So a lot of countries are developing transition plans, how they plan to move away from coal and fossil fuels, which is inevitable. But in Bulgaria, we're not seeing that discussion happen. So we're seeing derogations granted for an indefinite period of time, whereas the clock is ticking. They need to come up with a plan for the region and to comply with what is going to be the climate laws in the future.
And if I may just add one more thing on this, we didn't mention this in the presentation, but actually the derogation decisions requires the plant to make really small effort, so they are not really improving, and this is not the idea of the IED as we saw. So in a nutshell, we want to we want power plants to pollute less, and we want authorities to start caring about the health of people. And what is really concerning, as if we can conclude, what is really concerning in the case of Maritsa is 2, which is actually the first power plant being granted
I think we've lost Regina. So it seems to be the same fate as has arrived to me before. We don't have any other questions anymore at this stage, and we've also already gone over by 25 minutes. So I'm inclined to wrap up the session right now, unless there's any other closing words that either Sam or Dominique, anything else you wanted to add, something else that came up to the questions, or something you would want people to know? There's nothing coming from that side, so that's very good. So then I want to thank you very much all for taking part in the webinar today. I think we had really a lot of engagement, which I think justifies going over a little bit in time. And I hope that you've all learned so much as I have. And I hope that we can welcome you again at one of your on our future webinars. And if you have any other questions, please always feel free to send us an email. Thank you and have a good day.
Thanks, everyone.